Advertising is a fundamental part of real estate practice, but it is heavily regulated in Arizona to ensure truthfulness, accuracy, and consumer protection. According to ARS Paragraph 32.21013, advertising is defined broadly to include all forms of communication used by a licensee to promote real estate services or property for sale, lease, rent, or exchange. This includes print materials, signage, business cards, social media, websites, videos, and any other public representation that could influence a real estate transaction. Under AAC R4-28502, advertising by a licensee must always be truthful, not misleading, and must clearly identify the employing brokerage. These rules apply to all marketing activities, regardless of medium, ensuring the public can easily determine who is responsible for the advertisement and how to contact the brokerage. AAC R4-28502A prohibits blind ads, meaning advertisements that fail to clearly identify the name of the employing brokerage. For example, if a real estate agent posts a property for sale on social media and does not include the brokerage name, that is a blind ad and a violation of the commissioner's rules. AAC R4-28502B requires disclosure when a licensee is acting as both the owner and the agent of a property being sold or leased. The ad must clearly state owner-agent so that potential buyers understand the licensee's personal interest in the property. This prevents conflicts of interest and maintains transparency in all transactions. AAC R4-28502C forbids any advertising that misleads or deceives the public. This includes exaggerated claims, false pricing information, or promoting a property with details that do not exist. Licensees are expected to provide accurate, verifiable facts in all advertising materials. AAC R4-28502E mandates that the brokerage name must appear in a clear and prominent manner. The brokerage's name must be easily readable and not hidden in small print, abbreviations, or logos. The goal is to ensure the public can identify the responsible brokerage immediately. AAC R4-28502F governs advertising other brokers' listings. A licensee must have written permission before advertising or promoting another brokerage's listing. This protects property owners, prevents misleading representations, and maintains professional respect between brokerages. AAC R4-28502H clarifies that the term acre in advertising must mean exactly 43,560 square feet. This standardization prevents misrepresentation and ensures consistent, factual descriptions of land size. AAC R4-28502I requires the owner's written consent before placing a sign on their property. Licensees cannot post for sale or for lease signs without authorization. This rule protects property owners from unauthorized or premature advertising. ARS Paragraph 32.2153A 12 requires obedience to the owner's lawful instructions, including those related to advertising. If a property owner instructs an agent to advertise in a certain way or not to advertise at all, the licensee must comply as long as the request is legal and ethical. Promotional activities are regulated under AAC R4-28503 to ensure ethical marketing practices. According to AAC R4-28503A, any promotional items offered to attract clients, such as gifts or rewards, must be described as premiums, not as awards or prizes, which could mislead consumers into thinking they won something by chance. Under AAC R4-28503B, advertising a premium must clearly describe the terms and conditions of the offer, including eligibility and restrictions. The intent is to prevent deceptive promotional tactics. AAC R4-28503C prohibits the use of lotteries, drawings, or games of chance in real estate promotion. These types of promotions are considered gambling under Arizona law and fall under the jurisdiction of the Department of Gaming, which enforces gambling regulations. However, AAC R428503D provides limited exceptions for subdividers, timeshare developers, and membership camping operators, who are allowed specific types of promotional drawings under regulated conditions because their activities fall under separate statutory frameworks. AAC R428502G and R4281103A 5 make the employing broker responsible for supervising all advertising conducted by their agents. The broker must review, approve, and monitor all advertising content, ensuring compliance with the Commissioner's rules and preventing misleading statements. ARS Paragraph 322153A 4 prohibits unlicensed individuals from engaging in advertising that suggests they are performing real estate activities. For instance, an unlicensed assistant or staff member cannot advertise properties, hold open houses, or negotiate terms on behalf of a broker or client. Doing so constitutes unlicensed real estate activity and can lead to disciplinary action. Finally, AAC R10-112 prohibits discrimination in advertising. All real estate advertising must comply with federal and state fair housing laws, ensuring that no advertisement expresses a preference or limitation based on race, color, religion, sex, disability, familial status, or national origin. This applies to both print and online materials, reinforcing Arizona's commitment to equal housing opportunity.